Crypto Twitter is awash with the rumor of SEC Chairman Gary Gensler resigning from the regulatory agency. Pro-XRP attorney John Deaton commented on the rumors, saying a Gensler resignation. The long-running dispute between the U.S. Securities and Exchange Commission (SEC) and Ripple saw a partial resolution, which sent shockwaves across the cryptocurrency markets. The other side of the CCE's Ripple lawsuit might be expensive for Ripple, but many investors appear to be ignoring it. Ex-SEC employee John Reed Stark commented on the latest developments in the SEC's case against Ripple in a LinkedIn post. Stark makes it clear that even a partial victory for Ripple resides on shaky grounds. He does concede, though, that this is a setback for the SEC and its chairman, Gary Gensler. There are three distinct parts to the SEC's UVs. Ripple judgment, sale to corporations. Sales in this category are considered secure since they are made under contract to persons and institutions with a high level of expertise. The second kind of XRP sales includes automated trading platforms, and the court has ruled that XRP is not a security. Insiders, retail investors via exchanges, and the company's founders all make up the other sales category. As such, the XRP coin does not qualify as a security. The former SEC official cites this classification as one reason why the Ripple decision is troublesome on multiple fronts. He elaborates that the ruling would establish a class of quasi-securities that discriminates and morphs based on the sophistication of the investor who is buying the securities. As Stark puts it, this is counterintuitive, inconsistent with SEC case law, and unprecedented in this context. Whether or not XRP is considered a security depends on the level of expertise of the investors. This, as John Reed Stark puts it, seems contrary to sacrosanct and basic investor protection principles. Finally, Stark notes that the judgment implies that affluent investors are protected by the SEC, but ordinary and less skilled investors are not. Simply put, the poor have caveat emptor, whereas the wealthy have assistance and recourse. This is unfair and runs against the fundamental principles of US securities law. Although it is possible that the ruling in favor of Ripple and XRP backers may be reversed, doing so will take time as it must go through the appropriate procedures. Meanwhile, this verdict has the potential to set off a major bull market. The U.S. Securities and Exchange Commission (SEC) has replied to Judge Torres's groundbreaking order from the July 13 U.S. session. This followed the long-awaited summary ruling in the Ripple FZ SEC lawsuit. Annalisa Torres, the presiding judge, found that XRP is not a security in certain situations. The SEC replies to Ripple's shared victory. The U.S. SEC returned home with a partial victory and will battle again another day. Following the court's judgment, the Commission has declared their position in response to outrage and derision from XRP community members. According to Fox Business, the SEC may decide to pursue the issue further. To paraphrase a section of the answer, nonetheless, the agency celebrates its own triumph when the judge determined that Ripple offered and sold the tokens as investment contracts in violation of the securities laws in certain circumstances. According to the court's ruling, Ripple broke securities regulations by selling XRP to institutional investors. Judge Torres granted them permission to sell the asset to the general public. A summary judgment review reveals that the court agreed with the Commission that the Howey test regulates the securities examination of Bitcoin transactions. Ripple's view of what constituted an investment contract was similarly rejected by the court. Nonetheless, the court's judgment has made it obvious that the SEC does not have limitless authority over cryptocurrency, which may help to explain the crypto market's excitement. The Kraken and Coinbase exchanges have already responded to Ripple lawyer John Deaton's plea for exchanges to list or relist XRP as a gesture of support for the verdict. This demonstrates the cause for which the crypto industry is fighting, with crypto professionals such as Binance CEO applauding the Ripple camp on their victory. For one thing, it nullifies the SEC's action against Coinbase, which sold 13 tokens categorized as securities via the exchange rather than through launchpads such as ICOs or IOs. Nonetheless, CoinDesk blogger Preston Bryan believes that the July 13 verdict just ensures continuing ambiguity, which only Congress can resolve. For the time being, altcoins have flashed green after learning that Gensler no longer has sole jurisdiction over them, implying a buying frenzy that saw XRP detractors miss out on 70 gains while Solana, Sol, Polygon, Matic, and Cardano holders profited by around 20. The SEC's announcement discussed Ripple's partial victory and how the court rejected the defendant's proposed test. Since late 2020, the SEC's EVs, Ripple litigation has been ongoing. Now that we're in the third quarter of 2023, the globe is becoming impatient to hear the court's decision on this protracted dispute. Most people expect a favorable verdict in favor of XRP before the end of this quarter. The issue on everyone's mind right now is when the Ripple and XRP litigation will be resolved. A brief conversation about this occurred on Twitter among members of the online crypto community. Let's take a look at the many reasons why the XRP litigation has taken so long. According to this tweet, the reactions have definitely been about both parties of the litigation gaining time. According to one comment, the case generated a lot of attention, but if it takes a long time, people will lose interest. According to their remark, they predict that the value of XRP will ultimately skyrocket since it provides a valuable use case. As a result, investors of XRP, in their perspective, will acquire exponential riches over time. As a result, the SEC is attempting to lengthen the term of the litigation in order to dissuade interest, resulting in a smaller pool of persons profiting. Meanwhile, another respondent argues that the XRP litigation has taken so long because the court expects both parties to settle rather than go to war. At the same time, the same answer claims that Ripple is postponing the litigation in order to bring on additional on-demand liquid partners. Furthermore, according to another statement, the XRP case will not be resolved for another year. However, they failed to explain why they hold this opinion. Instead, another statement suggests that the XRP case might be extended for another year. According to this explanation, any and all delays are most likely attributable to the extremely sluggish speed of the American judicial system. On July 11, John Deaton disclosed some details about how much Judge Annalisa Torres charges for judgment on court matters. The XRP community is awaiting Judge Torres' verdict after Ripple and the U.S. Securities and Exchange Commission submitted reply papers in December. While it has been 7 months, Ripple is not Judge Torres' sole case. He said that the Thor Equities case's reply papers were also submitted in December, and that Judge Torres has yet to decide. He did, however, explain that Judge Torres delayed 7 months to announce her ruling in Quiller, Inc. versus Hughes, and 6 months in Fitzgerald case and numerous other instances. Deaton feels she has a good chance of ruling this month since she has taken her time. Ripple key to David Schwartz responded to Deaton, stating that he anticipates a summary judgment verdict would be issued before the end of September.